Good afternoon, everyone. Thank you for joining us for our employment law webinar. We know that you're busy, so we appreciate you taking the time to tune in and have a discussion with us. Please note that this webinar is being recorded and being broadcast live on Facebook. We hope that you are staying safe and healthy during this uncertain time. We will be circulating an email that contains a survey after this webinar. We spend a lot of time preparing for these webinars, and we want to make sure that you are getting the most benefit possible. Please fill out our survey and let us know your thoughts on the webinar and how we can improve. In these uncertain times, we know you're probably cooking a little bit more and perhaps are gearing up for your children returning to school in September. Everyone who fills out a survey will be sent a Walker Law branded maple syrup. Please note that these pancakes are for illustration purposes only. They are not included. Also in the email you will receive, it will contain some information about a charity that we have partnered with to provide used electronics to underprivileged communities. This is increasingly necessary as many students are now studying at home and need the necessary technology. So if you have old computers, tablets, or phones that you no longer use, please reach out to us at the email address which is located at the bottom right of your screen. Your email will also contain the links to register for our future webinars, so you can check them out on our webpage. And lastly, we know that you are very busy and may not be able to join us for a live webcast in the future. We might have missed some in the past. For those of you who have missed these webinars or TV appearances, they are available on the Walker Law YouTube channel. Please feel free to subscribe to it in order to receive up-to-date information on our videos that are uploaded. In this photo, I appeared on CTV's Your Morning on August the 10th to discuss the challenge that the City of Toronto is bringing against the province of Ontario regarding landlord and tenant law. So our agenda is as follows today. We will have a housekeeping and introduction to the panelists. We will provide to you an update on the government's response to COVID-19. We will answer your employment law questions, including clawback provisions, interpreting employment contracts, enforceability of non-compete phrases, changing contract terms, supporting employees, and fostering morale. And we will end off by answering any questions. So moving right into part one, which is housekeeping. So we received feedback before that the attendees did not like the fact that the video is at the tiny right side of your screen. And so it is possible to make the video and the slideshow more proportionate to each other. And how you do that is you click at the top, view options, you scroll down to side-by-side mode, and the slideshow will be almost the same size as the video that you'll see. To answer your questions, please drop them in as soon as they come to mind using the Q&A button, and we will answer them in writing, and try to answer as many out loud as possible. For those of you who submitted questions when you registered, most will be answered throughout the webinar, and to keep things confidential, we have referred to you by your initials. Please note that Jordan and I will continue to try our hardest to type all answers, even if we aren't able to read them all out loud. Next, responding to polls. So today's webinar will feature a number of polls to increase interactivity. We are including polls because we like to know what matters to you and where to focus our attention. So when we arrive at a poll menu will appear on your screen. Please submit the answer that you believe applies, and then click on submit on the bottom, and we will then share and discuss the results. Please note that those of you who are viewing this webinar on a mobile device may have a different experience than those who are using a computer when answering a poll. We recommend that if you can, watch this webinar from a laptop or desktop computer. So the roadmap for today's webinar will take an approach where we will try to understand your perspective by using the Zoom's poll features. We will ask for you to answer that question so then we can discuss it. And then we will discuss the correct answer and the law, and we will provide some tips on how to protect yourself in the future. So by the end of this webinar, we want you to understand new employment laws, and also an underlying theme is just because it's written in the employment contract, it does not mean that the court will enforce it. So some information about me. I am a trial lawyer and I graduated from McMaster University in 2002 with an honors commerce degree. I then attended Osgoode Hall Law School and in 2002, and then received my bachelor's of law degree in 2005. I was called to the bar in 2006. I practiced at two Bay Street firms before opening Walker Law 10 years ago, which now employs almost 10 employees. I am very fortunate to appear on a regular basis on a number of television stations, including CTV, CBC, and CP24 as a legal analyst. We are also very fortunate to have Jordan join us today. Jordan specializes in employment law, and he graduated from Dalhousie University in 2009 and obtained his law degree from Western Michigan in 2015. He was called to the Ontario Bar in 2018. So starting right into it, we're going to start off with a poll. And I'm going to ask you, what employment law issue concerns you the most? Changes in the law, interpreting employment contracts, enforceability of non-compete phrases, changing contract terms, laws to support employees and foster morale. Other, let us know using the Q&A. And I'll give it a few more seconds, about 5 more seconds. So sharing the results, it seems like most of you, it's a tie. Most of you are concerned about the changes in the law and laws to support employees and foster morale. So we'll make sure we spend a little bit more time on those issues. Thank you for voting. So now Jordan will start us off with a discussion on new COVID-19 legislative and court updates, and then you will elaborate on temporary layoffs as the law has changed since our webinar that was held a month ago. Jordan?
Thank you, Tanya. Hello, everyone. So as was indicated by the poll and the fact that we received some questions from a number of our registrants whose initials are listed here, a lot of people are interested in what some of the latest developments in the law are, and LT is specifically interested in the effect that these changes might have on gig workers. So I'll start off with the federal government. So the government of Canada has announced that the Canada Emergency Commercial Rent Assistance Act, CECRA, will be extended through the end of this month. At this point in time, there's been no indication that the CECRA will be extended any further, with the majority of the country having reopened for business. It seems likely that commercial tenants will be expected to meet all of their rental obligations going forward, and there will be no further extension, but we will wait and see. It's also been announced that there will be a transitional benefit instituted that will be for workers who exhaust CERB or the CERB and don't qualify for EI. It's been stated that this transitional benefit will look very much like EI, but it will be available to gig and contract workers as well. Also, this transitional benefit will include training for employees and also the ability to work more hours without a steep clawback in benefits that you would normally see under EI. The government has also promised that they will relax some of the EI eligibility requirements, such as the number of hours an employee would have previously had to work in order to qualify for EI. Finally, an online course has been announced by the federal government, which provides guidance on returning to work safely. This will not be an actual law that imposes legal obligations on employers, but it instead provides best practices that can be used as guidelines. And there is a link provided here on this slide, which can take you to this online course. Moving on to the provincial level, in Ontario, the state of emergency ended on July 24th, 2020. We will be discussing a little bit further in this webinar how this will affect temporary layoffs and what exactly this means for employers and employees. And that sort of ties into the next point as well, which is that the deemed infectious disease emergency leave is set to expire on September 4th, 2020. And finally, all areas of the province of Ontario have now moved into stage 3. And with this move to stage 3, that means that more businesses will be reopening, and hopefully many more employees will be returning to full-time work. And on the municipal level, the City of Toronto has announced that face coverings are now mandatory in condominium and apartment common areas. Now, face coverings were already mandatory in most enclosed spaces that were accessible to the public within the City of Toronto. And in our immediately previous employment webinar, we did discuss at some length the duties of employers in enforcing these requirements. I would encourage you to check out that previous webinar on our YouTube page if you missed it. Also on the municipal level, employment services for residents offered by the City of Toronto, such as job fairs and employment workshops, do remain suspended. There has not been any indication of when the city intends to resume these services, so we'll have to take a wait and see approach. Moving to the courts, the Superior Court of Ontario has increased drastically its use of technology that enables individuals to file most of their court documents, not only just to start their court proceeding, but also many of the documents that need to be filed throughout the course of a lawsuit. They have also introduced a new technology that enables parties to argue their cases fully virtually online. And on August 10th, in-person hearings were resumed in the Superior Court. Now, if you do wish for your hearing to be conducted virtually, and you're not comfortable appearing in person, you must submit a request to the court. However, there's no guarantee that this request will be approved, and you may be required to attend in person. This actually happened to Tanya and I on August 10th, the first day that courts were open again. We had put in a request and expected that our hearing would go forward virtually. However, on the Thursday evening before the Monday court date, we were informed that it would be heard in person, and we were required to physically attend court on August 10th. Okay, so now we had questions from a number of registrants. All of their initials are listed here. They were all interested in finding out what the end of Ontario's state of emergency actually means for employers regarding layoffs. Now, at the end of May, Ontario Regulation 228/20 was enacted. It was a regulation under the Employment Standards Act, or the ESA. And one of its facets was that it deemed any workers whose hours were temporarily reduced or fully eliminated as a result of COVID, it deemed them to be on infectious disease emergency leave rather than being laid off. It also specified that this particular aspect of the regulation would expire 6 weeks after the state of emergency in the province was lifted. And as you can see, that state of emergency was lifted on July 24th, 2020. So 6 weeks from that date takes us to September 4th, 2020. And as of that date, workers will no longer be deemed to be on the infectious disease emergency leave, and they must be recalled to work. Otherwise, they will be considered to be terminated and could potentially sue for wrongful dismissal damages. Excuse me. Now, one option that may be available to employers is to temporarily lay off some of their employees starting as of September 4th. It's important to know that temporary layoffs are only permitted where it is either accounted for in the original employment contract, or if the employee who is to be laid off agrees in writing to the layoff. So even if the layoff is agreed to and is permitted by law, it still must follow the terms of the Employment Standards Act, which require that the length of any layoff must be limited, in most cases, to 13 weeks in any 20-week period. Or in some exceptional circumstances, a temporary layoff can be extended for 35 weeks in any 52-week period. Now, that extended layoff would only be allowed in certain extreme circumstances under scenarios where, for example, the employer continues to pay a portion of the employee's salary or continues the employee's benefits all throughout the layoff. Now, if the employees are not recalled to work at the end of the temporary layoff, they are deemed to be terminated and can sue for wrongful dismissal. Or if they are recalled to work, but their hours remain significantly reduced, they have the option to resign and claim constructive dismissal. Now, constructive dismissal is a concept that we have discussed more in depth in previous webinars, but in a nutshell, it's a legal concept that occurs when an employer unilaterally changes some of the fundamental terms of an employee's contract. These can be terms such as the number of hours they're entitled to work or the amount of their pay. So when this happens and an employee is constructively dismissed, they are entitled to all of the same entitlements that an employee who is terminated or wrongfully dismissed under more regular circumstances would be entitled to, including notice of termination or pay in lieu of notice, and perhaps even severance pay. So now we do have a question before we move on. This one comes from IG, and IG is interested in what happens if you're laid off following a workplace accident and you have cooperated with the Ministry of Labor. Now, if you are injured at work and you follow all the proper procedure in reporting it to the ministry, if you are then terminated afterwards, your termination could be seen as a reprisal. Now, reprisal is basically any retaliatory action that an employer takes against an employee for the employee doing something that they were legally entitled to do, or in this case, legally required to do. Now, when a reprisal is alleged, the onus is on the employer to prove that there was no reprisal and that the termination or other discipline was actually made for a legitimate reason other than retaliation. If an employee is able to show that a reprisal occurred, the employee could be entitled to very significant damages on top of any other wrongful dismissal damages they may already be entitled to. Now, these would be what is known as punitive damages, which are intended to punish the employer for their wrongful or reprehensible behavior. We have another question here that comes from both TD and RS, and it says, does severance pay or termination pay impact CERB? And the short answer is yes, these would impact the CERB. Severance pay and termination or notice pay are both treated, at least for income tax purposes, as employment income. And one of the essential eligibility requirements for the CERB is that while collecting CERB, you may not earn more than $1,000 in either employment or self-employment income. So if you are receiving either severance or notice pay that amounts to more than $1,000 a month, then you would not be eligible to collect the CERB in that month. And that brings us to the next section of our webinar, where we will continue to answer some of your employment law questions. And it brings us to our second poll of the day. And this one deals with a concept known as clawbacks. So the scenario is such. An employee has signed an employment contract that says if terminated, she will receive her salary for 3 months. However, due to a loss in business, the company now wants to pay the employee the termination payments for 3 months, or only 50% of those payments if the employee obtains alternate employment during that time. And the question is, can the employer do this? Your options are A, yes, B, no, C, it depends, or D, unsure. And I'll give everyone a couple moments to plug in their answers.
Give it about 5 more seconds.
All right, so it seems that there were a variety of answers, but the majority, or 45%, so not quite the majority, but the most of you felt that no, the employer cannot do this. So I will now pass it back to Tanya, who will elaborate on the correct answer.
Thank you, Jordan. So the majority of you are correct. The answer is no, B. And the reason why is because a termination agreement alters the employment contract, and that cannot be done unless the employee agrees. We have seen this happen quite a bit recently, and perhaps it may be due to the fact that the employee may not remember the employment contract or the employer is falling on hard times. Regardless, when the employment termination agreement is signed, it is a binding contract. So the reason why there's a need for that clawback provision, the 50% pay just in case you find a new job, is because we have this law called the Employment Standards Act, which says when an employee has worked with your company for 1 year and they're terminated, technically speaking, they're entitled to 1 week of pay in lieu of notice. The judges have altered this law and said the 1 week per year, up to 8 weeks, is not enough time for an employee to pay their bills while actively looking for a job. And they've created their own law called the common law, which is roughly about 1 month per year that the employee has worked for the company. So now employers who wish to downsize may have the problem of paying 1 month per year of salary. And now the employees who have worked there may not feel the need to look for another job very quickly if they know that they're going to get 1 month of salary per year for the amount of years that they've worked there. So that's why we have clawbacks. So leading into the question from JM, what is the benefit for early termination of contract? If you do have a clawback, that is a benefit because it will help save the employer money, who might end up paying 50% of that person's termination pay. And it might help the employee who finds a new job and continues to make 50% from their previous employer. But please note that a clawback under the Employment Standards Act cannot be can't go against the Employment Standards Act. So what that means is if that person who worked for the company for 1 year is entitled to 1 week of pay in lieu of notice and they find a job in 2 days, you still have to pay them out for that 1 week or 1 month, whatever you agree on. But the minimum is 1 week. So MB asked, what about severance and when do you consider getting legal advice? And my suggestion for employers is before you hire the employee, so you can make sure your contract has the right phrases, or when you're thinking of terminating the employee, so you can make sure you have the right warnings or the right documentation in place. If you are the employee, I would suggest that you retain a lawyer before you sign your employment contract, or at the very least before you are terminated if you sense you're going to be terminated, so then you can receive some advice about how to deal with your termination so you have the documentation in place in order to negotiate a very good termination package. So solutions going forward, tips for employers, I would say make sure you negotiate what the employee will receive when that employee is terminated before the employee starts to work for you. Sometimes we deal with situations where we're saying, okay, well, 1 month per year, 2 weeks per year, are going back and forth. And the easiest thing for the employer is to have that dealt with before the employee even starts to work for you. Make sure that the employee initials any paragraph such as this to demonstrate that he or she actually understood and fully understood the paragraph. Give the employee the opportunity to receive legal advice before signing an employment contract, and definitely do that when the employee is terminated, and define when a clawback would apply. If you're an employer and you want to have in the termination agreement 50% pay if the employee gets another job, is that part-time, full-time, temporary? Make sure it's clearly defined. Tips for employees, don't sign termination paperwork right away. I heard somewhere around 70% of employees that are terminated just sign the paperwork. You should make sure that you get some legal advice and make sure at minimum the termination paperwork complies with the Employment Standards Act. So going forward, here's a sample phrase that you may want to consider implementing in your contracts. And I highlighted in red what is really fundamental. And what you're looking at here is if you work for you're entitled to maybe 1 month of pay in lieu of notice per year employed. If you are terminated, you will get 50% of the settlement funds remaining and no less than the Employment Standards Act. You have a strict duty to report any new employment, and if you do, there will be consequences such as repaying what you received back to your employer. So we'll pause right now for any questions. Feel free to type in any questions you may have, and after every section, we'll pause and answer them. But these are questions submitted when those of you who registered, and the first question is in what situations are employers using COVID as a reason to terminate without any form of pay? The answer to this is you can't terminate without any form of pay unless there's a reason to terminate the employee. So if there's theft, misappropriation, any reason to terminate that employee with cause, that is the only time you really can terminate without any form of pay. A question from TM is, what are the required warnings necessary to terminate an employee without payment of severance? And an example of that is illustrated in Chopra versus Easy Plastic Containers. And what happened in this situation was the employee was terminated after being provided with written and verbal warnings. The employee claimed termination pay, and that the termination was a reprisal for bringing legitimate health and safety concerns. The court decided that the employee was justified in terminating the employee because of all the performance issues and insubordination, and this was documented 6 times in writing. There was one verbal warning that was also documented. So the answer for you employers is, if you are experiencing problems with an employee, please document all the interactions with the employee where you gave that employee warning if you're considering terminating that employee in the future for cause and without termination pay. So I'll bring you to the next poll, which is interpreting employment contracts. And in this situation, you are going to pretend to be the judge. And so your situation is, an employee was terminated without a reason from the XYZ company, but the court did not like the termination with a reason phrase and said it was invalid. So you terminate your employee without any reason, and the contract looking at the with the reason phrase, like fraud, misappropriation, that doesn't even apply to the situation. The court didn't like it. So will the rest of the contract be upheld? Your possible answers are yes, no, unsure, and it depends. And this answer leads into the question sent by SS, which is, what potential employment law issues could there be for an employer? So could you please vote? And I'll give you about 5 more seconds. So the majority of you said yes, the rest of the contract will be upheld. And it's a tie. 24% of you said no, 24% of you said you're unsure, and 7% of you said that it depends. So I will ask Jordan to provide to you the correct answer.
Thank you, Tanya. So somewhat surprisingly, the answer is actually B, no. This issue was dealt with in a case that was heard this year by the Ontario Court of Appeal, which is the highest court in Ontario. It was called Waxdale versus Swegan. And in that case, the Court of Appeal held that an employment contract must be interpreted as a whole and not on a piece-by-piece basis. This is a bit of a departure from what we normally see, because normally most contracts, not just employment contracts, but most of them will include what is called a severability phrase. And that phrase will state that if one portion of the contract is found to be unenforceable, you can separate that phrase from the rest of the contract, and the rest of the contract will remain enforceable. Here, however, the Court of Appeal held that the severability phrase did not apply, and it would not save the rest of the contract from being unenforceable. There was also another case that was heard this year in the Ontario Superior Court called Rutledge versus Kanan. And in that case, the court held that if a phrase in an employment contract could even conceivably violate the Employment Standards Act, then it actually did violate the act. Now, one example of how this could come about, which is actually what happened in that case, is that under the ESA, employees are entitled to severance pay, which is different than notice, only if they're terminated after having worked for one employer for at least 5 years, and if the employer has a payroll of at least $2.5 million, or has terminated at least 50 employees within a period of 6 months. Now, in this case, the employer did not have a payroll anywhere near $2.5 million, and they did not have 50 employees to terminate. So they felt they were safe from severance pay and included a term in the contract that specified that employees were not entitled to severance upon termination. However, the court held that it was conceivable that someday this employer could have a payroll of $2.5 million or more, or could have 50 more employees that they terminated within 6 months. So as a result, because it was possible that one day the employment contract would be non-compliant with the ESA, they found that it actually was in violation and would not be enforceable. Now, it is worth mentioning that this was heard by the Superior Court of Ontario, so there is a chance that this higher standard that's been set by this case could be revisited by an appeals court, either the Ontario Court of Appeal or the Supreme Court of Canada. However, no appeal has been filed yet, as far as we know. So if we go to the next slide, please. So seeing as a severability clause will no longer save your employment contract if any part of it is non-compliant with the ESA or even has the potential of becoming non-compliant with the ESA, the best practice that you can really do is make sure that every single phrase that is included in your employment contract complies with the statutory minimum entitlements that are required under the ESA. Now, the best practice for ensuring all the minimum entitlements are met would really be to make sure that any employment contracts that you have are reviewed by an by an employment lawyer who's well-versed in the ESA before you present this employment contract to any potential employees for signing. And we actually have a sample contract on the next slide. I won't read the entire termination phrase, but I will point out that the most important parts are highlighted in red. The one that says, at no time will the employee receive less than his/her full entitlements under the ESA. It's important that you state this so that even if all of the minimum entitlements are not explicitly stated in your contract, this provides that at least there's no circumstance where you will not be giving the employee their minimum entitlements. And also, the very last phrase, the employee is not entitled to common law notice. This just makes clear that they're only entitled to the statutory minimums and not common law notice. As Tanya mentioned earlier, the ESA entitlements to notice are much lower, about 1 week per year of employment, up to a maximum of 8 weeks, whereas under the common law, they're closer to 1 month of notice per year and can sometimes be as high as 30 or more months of notice. Next slide, please. Now we have a number of questions. The first one comes from IH, and they ask, are there any specific rights that minorities have to apply to certain jobs or to be entitled to a certain pay scale? The answer to this question is really sort of. In Canada, we do have the Employment Equity Act, and that imposes a duty on employers to identify and eliminate any barriers that may be in place against persons in designated groups, such as visible minorities. And it imposes a duty on the employers to institute positive policies and procedures that will ensure that members of these certain groups achieve a degree of representation in every working group within that employer's workforce. However, it does not require employers to hire or promote people just because they are a member of a designated group if they do not otherwise meet the essential requirements of that job. It is worth noting that this act is only a federal act and only applies to federal jobs. There is no equivalent legislation in Ontario, but the Ontario Human Rights Commission has gone on record and specified that the idea that some might put forth that taking proactive action against racism is somehow a reverse racism against white people. They've specified that this idea is a myth, and they've warned that employers should be very cautious not to rely on such myths. For an anecdotal example of such a job being available only to certain groups. In 2008, my alma mater, Dalhousie University, was looking to fill a managerial position, and it announced that they would only be seeking applications from racially visible or Aboriginal candidates. Now, this caused a fair bit of controversy and debate on both sides about whether this was proper or the right thing to do. However, there was no legal reason that Dalhousie was not allowed to move forward with this course of action. Okay, we have our next question, which comes from NW, and that states, what is the requirement of joint health and safety committees during the pandemic? Now, for those of you who may not be familiar with this term, basically joint health and safety committees are groups that are formed within businesses, and their major function really is to identify potential health and safety hazards that may be present in the workplace. And they also make recommendations on how these hazards could be fixed, prevented, or improved. So during the pandemic, there aren't really any functions or requirements that are different for joint health and safety committees. It would just be that there may be certain hazards that relate specifically to COVID that they would be more responsible for identifying and providing suggestions about how policies can be bettered. This could include recommendations they make regarding hygiene policies in the workplace, the availability of cleaning and disinfectant products, training policies for employees with personal protective equipment, and also policies regarding social distancing. I hope that answers that question. So then we also have a question from CD, which relates to vacation time entitlement and possible carryover. And this is actually a topic that has created a lot of confusion over the years among employees and employers. So basically, under the Employment Standards Act, workers who have provided less than 5 years of service to any employer are entitled to 2 weeks of vacation time for every 12-month entitlement period that they work. Workers with 5 years or more of service are entitled to 3 weeks vacation time for any 12-week entitlement period, 12-month, entitlement period in which they have worked. That vacation entitlement is actually required by the ESA to be taken within 10 months of the end of any entitlement period. And if it is not taken within those 10 months, then it's actually the employer who is considered to be in breach of the ESA. So for that reason, if an employee is not scheduling their vacation time within the 10 months or is actually refusing to schedule their vacation time, the employer is actually allowed to require the employee to take the vacation time at a time specified by the employer. An employee can forfeit their right to vacation time in a specific period, but that can only be done if it's put in writing and signed off on by the employee. Regarding carryover, there is no carryover provided for in the Employment Standards Act, but in reality and in practice, it's a situation that arises quite often, either due to workload or just scheduling problems. So any employment contract that employers enter into should really specify how unused vacation time is to be treated, and how or when carryover will be taken if it is permitted at all. Next slide, please. And that brings us to another poll, and this one relates to enforceability of non-compete phrases in contracts. So for the purpose of this poll, we will be asking you to play the judge. And the situation here is that a cashier signed an employment contract with company ABC that said after she leaves the company, she cannot work as a cashier for competitor XYZ for 1 year after she leaves the company. She left, and within 2 months, she started to work as a cashier for competitor XYZ. What would you decide if you were the judge at court? What is your verdict? So the options here are A, she cannot work with XYZ. B, she can work with XYZ. C, unsure. Or D, it depends. And I would ask everyone to put in their answers.
Give it about 5 more seconds.
All right. Okay. So it seems that the majority here feel that the answer is A, she cannot work with XYZ. A fairly large number of you also felt that she could work with XYZ. 8% were unsure, and 25% said it depends. So Tanya, could you please provide the answer?
Sure. Thank you, Jordan. So the answer is B. She can work with company XYZ. And as a general rule, what we were asking you to decide on as a judge was a non-compete phrase. And starting point is they're not allowed. Judges don't like them because it prevents a person from earning a living. So in order to enforce a non-compete phrase, the employer must establish 2 things. The first is that the employer's interest is not protected by having a non-solicitation phrase and a non-disclosure phrase. A non-solicitation phrase means you agree as an employee that you will not try to take any of the other employees of that company with you when you leave. A non-disclosure phrase is that you will agree to keep confidential information confidential. Secondly, the employer must also demonstrate that the employee actually has access to some form of trade secrets that would give the competitor an unfair advantage to even have this considered. So because this person who left the company is a cashier, it is very unlikely that that person would have access to trade secrets to give a competitor an advantage. So even if company ABC brought that cashier to court, the judge is likely to say, I'm not upholding this law, this phrase that this cashier agreed to, because you're just trying to prevent this person from earning a living. So some suggested practices going forward is be specific about the length of a non-compete phrase if you must have one in your contract. Name the competitors, the type of job, and even the geographical scope. The more narrow and specific it is, the more likely it will be upheld. And also use non-solicit phrases and confidentiality phrases to protect your employment interest. So an example of this phrase is here, where it's very specific. It says for 6 months, you will not work within 15 kilometers, which might be, depends where the 15 kilometers is. In Toronto, 15 kilometers might be too large, where somewhere else that's rural, that would be okay. You will not accept direct employment with a direct competitor of the employer. They actually name ABC companies, and you understand this as an employee, and you're encouraged to obtain independent legal advice in reference to this agreement. So Jordan, I might ask you to join me back here because there's a few questions that were asked, but one question that was asked when someone registered is, I would like to know about what issues are surrounding hiring during COVID. And some issues I think of is whether this person would be working from home, coming into the office. Then if this person's at home, what kind of cybersecurity is there at home? What kind of security is there period at home concerning like a laptop and access? Whether the new hire has any disabilities that the employer would need to accommodate, how can they make such accommodations, and whether certain benefits should be included in the employment contract that relate to COVID, such as subsidies for childcare, mental wellness programs, etc. So Jordan, there was a question that I think you might be better suited to answer, and it's from Linda, where it says, what are my rights or next steps as an employee if not asked to return to my duties before CEWS ends?
Okay, so if you're not asked to return to your duties and you're not receiving any payment under the CEWS, it again depends if there was anything in your contract regarding temporary layoffs. If there was nothing and you're not receiving any income through the CEWS, then I would submit that you're likely terminated as soon as you stop receiving any payments. There's been a fundamental change to the terms of your contract in that I assume your contract specified that you were supposed to receive some income or at least some hours of work, and now you're receiving neither. So you would have the right to claim constructive dismissal, and then you would be entitled to notice or termination damages.
Thanks, Jordan. So I'll move on to the next poll. And a number of you asked this question. An employer wishes to change the terms of the employee's contract post-COVID. That would affect the employee's salary, benefits, or entitlements upon termination of employment. The question that we received from many of you is the employer even allowed to make these changes? So the possible answers are yes, the employer may, no, it depends, or unsure. Could you please vote? And I'll give you about 5 more seconds. And sharing the results, 50% of you believe that it depends, and followed by no, the employer cannot make these changes. And some of you believe yes. So Jordan, would you provide the answer?
Yes, thank you, Tanya. The majority of you were correct. The answer is C, it does depend. So in order for any contract, including employment contracts, to be formed and to be valid and binding and actually enforceable, there are some elements that need to be present. The first is that there needs to be an offer made. The second is that there has to be an acceptance of the offer. And the third is that there has to be consideration present. Now, consideration is just a legal word that basically means a benefit that is provided from one party to the contract to another. And in order for it to be valid, consideration must be provided and received by every party to the contract. The most basic example I could think of to give you, especially in the employment sphere, would be an employee promises to work for the employer, and the employer promises to pay the employee for their work. So there's consideration on both sides, and the agreement will be binding. However, anytime there are changes that are going to be made to a contract, there must be new consideration provided on all sides as well. So if an employer wants to make changes to a contract that only benefit the employer, but do not provide any new consideration to the employee, the contract will be unenforceable. It's also worth mentioning that if the employer is unilaterally trying to change some of the major terms of the contract, as we previously discussed, the employee would have the right to refuse to accept those changes, resign, and then claim constructive dismissal, under which case they would be entitled to termination pay. And I see we do have a question at the top of this slide. Asking, are there any changes to contracts employees should be wary of in these trying times? Now, there is one idea that I've been seeing some articles written about that says there's some concern over the potential that some employers might try to lower the salary of employees who are now working entirely from home based on the cost of living where they live. And the reasoning behind this idea is that if someone was previously expected to come into the office every day and their office was in downtown Toronto, they would presumably live somewhere in the greater Toronto area where the cost of living is fairly high. But now, since if they're only going to be working from home, they could conceivably live anywhere. They could be in the Northwest Territories or somewhere where the cost of living is significantly lower, and they could be doing all their work from their home. So there's some concern that employers are going to try to lower salaries based on this. It's unclear at this point if that would actually be legal. It hasn't really been litigated, but my thinking is that it wouldn't be legal unless the existing contracts already specified that part of the employee's salary was tied to the cost of living where they lived. And I would also submit that the employee would have to actually move to somewhere with a lower cost of living before a reduction in salary would be allowed, because it would obviously not be fair if an employer were to say, oh, since you work from home now, I'm going to lower your salary because you have the option of moving to the Northwest Territories and working from there, and you could save a lot of money on rent. That I can't see that being held up by the courts. Next slide, please. Okay, and we do have some more questions on this slide. The first deals with negotiating a pay raise or changes in contract, for example, from a worker to salary, contract worker to salary. And the other question from TK, JM, and NP is, how can an employer misuse the pandemic to take advantage of you? Well, for that second question about an employer taking advantage of you, that kind of ties into the example I just gave, where an employer may try to reduce your salary based on cost of living if you're working remotely. And I would say that both of these questions would kind of be applicable to a situation where an employer may wish to change their contract to include a termination phrase, which is something we've already discussed and said that it would be a best practice for all employers to have such termination phrases in their contracts, so that they would only have to provide ESA minimum entitlements rather than common law. But so what an employee can take from this is, now knowing what we know about consideration, if your employer does wish to change a contract to include such a phrase, they have to provide you with something as well. So that could be a pay raise, it could be a change in the type of worker you are, from contract to salaried. There are a number of benefits that could be provided as consideration to the employee. Some other ones might include a raise, which I already mentioned, but some other examples that are more applicable to the pandemic right now could be offering more flexible work hours, providing subsidies for childcare, or paying for equipment for the employee's home office. Now you can kind of see how, for an employee, how they could use the opportunity of a suggested change in contract to benefit them by requesting consideration that is most tailored to their own personal needs. But at the same time, it can also benefit an employer because they can use it as a good opportunity to provide support to their employees and foster morale in the workplace. And Tanya is now going to speak about some laws and policies that employers can keep in mind with regard to the issue of morale in the workplace.
Thank you, Jordan. That brings us to our last topic for today, and a topic that many of you are concerned about is what laws or policies are available to help employee morale, job security, or accommodate children. And so I want to start off by saying that employees are juggling working from home, possible feelings of isolation, and perhaps caregiving. So now more than ever, the employee may be entitled to human rights accommodations under the protected ground of family status or disability if it's COVID related. A duty to accommodate is necessary unless it is an undue burden such that it will make you perhaps lose a lot of business, go out of business, but you have to accommodate as an employer. With COVID, keep in mind changes may be permanent and you may want to just consider treating them this way. And I want to explain the duty to accommodate with two cases. The first case is called Hamilton-Wentworth District School Board versus Fair, and that was decided by the Court of Appeal. They both were. So that meant they were decided at the Human Rights Tribunal, appealed to Divisional Court, and then appealed to the Ontario Court of Appeal, which is the highest court in our province. And what happened in that situation was Ms. Fair worked with the Hamilton-Wentworth School Board as a supervisor in asbestos. She shortly developed an anxiety disorder and was diagnosed with depression and post-traumatic stress, which later developed in response to the stressful nature of her position. She went on medical leave of absence for approximately 2 years, and she wanted to return to work, but her doctor said she couldn't. And when she returns, she can't do any work that involves personal liability because her job is so stressful. So when she was returned to work, she was interviewed for 2 positions. She couldn't be accommodated, and she was later terminated. And the issues are around the 2 positions. So the first position, the school board got rid of it because they said that there are budgetary restrictions. The Court of Appeal did not agree that the school board actually demonstrated that there was budgetary restrictions and it could not afford to keep that position open. The second position, another candidate who was more qualified than Ms. Fair was hired, and the Court of Appeal said for that Sometimes when it comes to accommodating someone with a disability, the employer in the appropriate case might be required to hire not the best candidate for the job, but the person who is qualified for the job in order to accommodate a person with a disability. Second case is Nason versus Thunder Bay Orthopedic. And what had happened in that situation, the employer was able to demonstrate to the court an undue burden and hardship, an undue hardship. And what happened in that situation was an orthotic technician developed problems with his arms as a result of his work. So he was allowed to work at a pace that's compatible with his condition. He was allowed rest breaks at his discretion and breaks to perform stretching exercises, told not to use his computer at lunch and rest his hands and wrists. So he was also allowed to pay time off to attend doctor's appointments and physiotherapy, and he was no longer required to do cast modifications because it was too physically demanding. His situation got worse. His productivity declined by 50% to what it should have been, and it also caused a burden on his co-workers where they were working 12 to 13 hours each more a week to make up for that workload. And so the court in that situation said that the employer is not required to create a new position for the employee or make fundamental changes to the employee's job or working condition. And hardship becomes undue when the employee cannot fulfill the basic obligations of his employment position despite accommodations. The court agreed that this was not sustainable. So the takeaway from this is, when it comes to COVID, I would recommend employers try to accommodate their employees as much as possible, document that accommodation, document any decrease in productivity before saying that we can't accommodate you and you're terminated. So the last part are questions that have been asked, and there's one from PG and ND where it was asked, what are employee rights regarding safety when he or she returns to the office? So earlier, Jordan pointed to the federal government's plan. This is the provincial government's plan, and you'll receive a copy of these slides after the webinar, so you can just click on the link. They're divided for the provincial plan. It's actually divided into sectors, but it's looking at sanitization for office workers, even checking that person's temperature. There's quite the list for office workers. Also, there's questions from BB, KS, and OI. Suppose the employee does not want to go back to the office. What rights does the employee have, if any? Can the employee be fired? My answer is it depends. If the employee does not want to go back to the office because of childcare issues or maybe symptomatic with the immune system, then I would recommend really trying hard to accommodate that employee if possible. If a general discomfort, you also have to think about productivity. Someone is not going to be as productive if they're not comfortable in the office, but it doesn't give as much of a answer of yes, work from home if the person says I'm a little uncomfortable. And I just want you to note that the right to refuse work, it cannot be part of the job. Like a medical lab technologist cannot refuse to handle a blood sample with an infectious disease unless the appropriate controls are not in place. So you have to look at, are the controls in place? A question from LD is, what is the right way to disclose a disability when it comes to employment? And I would answer, it depends on if the disability affects your ability to do the job. In the example of the orthotic technician, if there's a disability that prevents you from lifting, you might want to disclose that in your interview to see if any accommodation can be made, or even when you apply. And I'm just going to, we have about 1 minute left remaining. Jordan, I don't know if you can join us. We can answer some of the questions that have been asked. So anonymous attendee asked in the Q&A, is there a way to handle other employees' discomfort with a returning employee who was diagnosed with COVID more than 2 weeks prior? If it's possible to provide some kind of counseling. What we've done in our office is there's only half of us here, and I've had to move cubicles around. So those of us who are not in offices, the other people who are in cubicles, they're on opposite ends of the office, and no one was diagnosed with COVID, but it's just to help with that discomfort. I would probably recommend you to think about temperature, taking everyone's temperature on a daily basis, depending on what kind of industry you're in. That's what I suggest. So I don't know if you want to add anything, Jordan?
No, I agree. I think the best way to ease the discomfort of other employees would just be have really strong policies in place regarding health and safety in the workplace, or as you mentioned, to provide counseling if necessary.
Yeah, so it's 1 o'clock right now, and I just want to say thank you so much for joining us. I really appreciate you taking time out of your busy schedules to spend it with us. There's so many webinars, so I'm glad that you selected us to spend your time with. If you have any other questions, feel free to reach out to Jordan or I, and you'll receive a copy of this webinar shortly after it's uploaded on YouTube. So thanks again, everyone. I hope you have a wonderful day, and that you continue to stay safe and healthy. Thank you. Thanks, Jordan.